On behalf of the Center for Discourses on Criminal and Constitutional Jurisprudence, I welcome you all to our third discourse. The Center was conceived with the vision to provide a platform for continuous learning via lectures, discussions, and the like on various fundamental conceptions and principles that are vital for our legal system and its development, especially in the fields of criminal and constitutional law. This humble initiative, undertaken by a group of young lawyers, hopes that, in whatever little measure possible, the same might contribute to the onward march of jurisprudence via sowing the seeds of constructive thought. At our first inaugural discourse, we had the pleasure of Justice Siddharth Mridul, ex-Chief Justice of Manipur, Justice Anup Jairam Bhambani of the Delhi High Court, Mr. Hariharan, Senior Advocate, and Mr. Arun Mohan, Senior Advocate, holding forth. At our second discourse, we were fortunate to have Justice Hema Kohli of the Supreme Court, Justice Ori of the Delhi High Court, and Ms. Rebecca John, Senior Advocate, share their wisdom. We would like to thank all of our speakers today for taking the time out of their busy schedules to be here with us. To inaugurate our third discourse, we shall begin with the lighting of the lamp. We request the speakers, along with our founders, Mr. Harsh Prabhakar, Advocate, and Mr. Akshay Bhandari, Advocate, to proceed with the same. On behalf of the Center, Ms. Kaveri Birbal, Advocate, will now present a small token of our appreciation to His Lordship, Justice Anish Dayal. We now request Mr. Parmesh Bali, Advocate, to present a small gesture of our gratefulness to Justice Muralidhar. Ms. Taira Karpalia, Advocate, will now present the same to Mr. Sorup Kirpal, Senior Advocate. We are also grateful for the presence and blessings of the esteemed sitting judges of the Delhi High Court, as well as for the presence of the learned judicial officers. Mr. Pratham Sharma, Advocate, will present a small token of appreciation to Justice Bhambani. Our first speaker is the Honorable Justice Anish Dayal. Honorable Justice Anish Dayal was born in 1973 in Allahabad. Justice Dayal graduated in Physics Honours from St. Stephen's College, Delhi University, and pursued his law degree along with his master's at Churchill College, University of Cambridge, United Kingdom, as a Commonwealth Scholar. He enrolled as an advocate in the year 1995 and practiced for over 25 years, primarily before the Supreme Court of India and the Delhi High Court, dealing with cases involving civil, constitutional, and commercial law, with a special focus on media, entertainment, and sports law. Justice Dayal significantly contributed to legal academia by authoring important sections in Halsbury's Laws of India and writing columns for Live Mint and the Wall Street Journal. Further, he conceived, curated, and was part of the editorial board of Quarterly Bar Review, a journal of the Delhi High Court Bar Association. In March 2021, Justice Dayal was designated a senior advocate by the Delhi High Court and elevated to the bench on 2nd June 2022. One of his early contributions came in Vikas Sangwan versus State, where a division bench comprising of Justice Mukta Gupta and Justice Dayal dealt with critical issues under the Juvenile Justice, Care and Protection of Children Act 2015. The High Court raised concern over the unconstitutional practice of extracting confessions from children in conflict with law during preliminary assessments. It observed that the exercise of seeking a confession from a child is unconstitutional, as it undermines the protective intent of the statute. It was emphasized by the High Court that such assessments must be guided by the factors laid down by the Honorable Supreme Court, namely the child's mental and physical capacity, ability to understand consequences, and the circumstances of the alleged act. This intervention stands as a significant reaffirmation of the judiciary's role in ensuring that the justice system remains sensitive, rehabilitative, and protective towards adolescents. Justice Dayal is presently serving as a member of the Juvenile Justice Committee of the Delhi High Court, which is entrusted with monitoring the conditions of the Nirmal Chhaya Home for Girls and overseeing systemic issues relating to the functioning of observation and remand homes under the Juvenile Justice Act. Further, in CCLK versus State of NCT of Delhi, which was recently pronounced, Justice Dayal addressed a fundamental question under the Juvenile Justice Act. That is, whether a child in conflict with law, even when directed to be tried as an adult, pursuant to a preliminary assessment, could be subjected to a joint trial with an adult offender. Justice Dayal emphatically held that a joint trial is impermissible. He drew a vital distinction between the statutory expression as an adult, which permits a stricter mode of trial before the Children's Court, and the erroneous construction of with an adult. The judgment reaffirmed the categorical legislative bar under Section 23 of the Juvenile Justice Act, which prohibits joint proceedings of a child with a person who is not a child, notwithstanding the provisions of the Criminal Procedure Code. In his analysis, Justice Dayal underscored the following aspects. Child remains a child in law. Even when transferred for trial as an adult, the individual does not lose the status of being a child in conflict with law. The trial is only conducted under a different framework considering the seriousness of the alleged offense. Protection against stigma and prejudice. A joint trial with an adult offender would erode the rehabilitative ethos of the Act, risk stigmatization, and expose the child to prejudicial consequences. Plain language of Section 23. By invoking the principles of statutory interpretation, the court emphasized that Section 23's prohibition is absolute and overrides all other laws, reflecting legislative intent to safeguard children from the harshness of the adult criminal justice system. Reinforcement of child-centric justice. The ruling reiterated that the Juvenile Justice Act is a beneficial legislation meant to ensure that the juvenile justice remains reformative and offender-oriented rather than punitive and offense-oriented. Through this judgment, Justice Dayal not only clarified a crucial interpretative issue, but also fortified the jurisprudential foundation of juvenile justice in India, ensuring that the statutory protections for children remain meaningful and robust in practice. Justice Dayal is also a published author. His book of poems, titled Can It Get Worse?, is a playful and creative collection of 9 poems written for children and really for anyone who can be one. Inspired by his love for words, the book reflects his creative side. Laudably, All the proceeds from the sale of this literary work have been dedicated to Justice Dayal's Village Libraries initiative for children in Uttarakhand. Our second speaker is the Honorable Justice Muralidhar. Honorable Justice Muralidhar is a distinguished lawyer and former Chief Justice of the Orissa High Court. Justice Muralidhar began his legal practice in Chennai in the year 1984 before moving to Delhi in 1987. While in Delhi, he practiced extensively at the Supreme Court of India and the Delhi High Court. He also served as counsel for the National Human Rights Commission and the Election Commission of India, which was a part-time member of the Law Commission of India. He has been deeply engaged in public interest litigation, having assisted the court as amicus curiae in several significant matters and represented the victims of the Bhopal gas tragedy on a pro bono basis. He was awarded a PhD by Delhi University for his work on the role of legal aid in the criminal justice system and authored the acclaimed book, Law, Poverty, and Legal Aid, Access to Criminal Justice. Elevated as judge of the Delhi High Court in 2006, he delivered path-breaking judgments in diverse areas such as gender equality, urban planning, constitutional rights, and criminal justice. Notably, he was part of the division bench that decriminalized consensual adult same-sex relations in the Nas Foundation case and was known for progressive judgments on the right to housing, gender discrimination, and the right to health. In Ajay Markan versus Union of India, a division bench comprising of Justice Muralidhar and Justice Bakru, while deliberating over the issue of forced eviction of nearly 5,000 Jhuggi dwellers in Shakur Basti, held that the right to housing is a bundle of rights, which includes the right to livelihood, health, education, food, clean drinking water, sewage, and transport facilities. Rejecting the narrow view of Jhuggi dwellers as illegal occupants, the court recognized them as rights bearers entitled to constitutional protection and emphasized the duty of the state to ensure proper rehabilitation under the Delhi Urban Shelter Improvement Board Act 2010 and its policies. Equally significant was State versus Sanjay Kumar Valmiki, involving the serious charges of kidnapping, rape, and murder. While fully conscious of the barbarity of the crime, Justice Muralidhar turned the court's focus on the manner of trial, pointing to grave irregularities such as hurried proceedings, inadequate representation, and denial of fair opportunity to challenge forensic evidence. His judgment reaffirmed the cardinal principle, i.e., even in the most heinous crimes, justice cannot be secured by rushing proceedings or compromising due process. He reminded that a trial in haste is justice denied, and that the fairness of the process is non-negotiable in a constitutional democracy. It would also be important to talk about Justice Muralidhar's seminal contributions in the area of legal aid while holding the position of Chairman, Delhi High Court Legal Services Committee. He initiated outreach programs and organized periodic visits to Foreigners Detention Center, children's homes, and housing juvenile delinquents, and conducted an audit of the enforcement of provisions of the Juvenile Justice Act 2015 through panel councils. He also focused on capacity building of legal aid lawyers and towards this end conducted numerous training sessions. For the purpose of engendering sensitization of panel counsels, in a first of its sorts, he also organized an interaction of the Legal Services Committee lawyers with a litigant indicted of terror charges who had availed legal aid before the Delhi High Court and was consequently acquitted by the Delhi High Court. He served as Chief Justice of the Orissa High Court from January 2021 until his retirement in August 2023, during which he pioneered judicial reforms, including the digitization of court records and the establishment of regional judicial academies. Post-demitting office, Justice Muralidhar continues his quest to serve the institution at different levels. He practices before various high courts and the Supreme Court. Further, as an academician, he offers his deep insights into the challenges confronting the judicial system. His most recent academic work is Incomplete Justice, which critically examines the Supreme Court's role, accountability, and the challenges of delivering complete justice. Our next speaker will be Mr. Sorup Kirpal, Senior Advocate. After studying physics at St. Stephen's College in Delhi, Mr. Saurabh Kirpal read law at the University of Oxford and did his master's in law at the University of Cambridge. He did a brief stint working with the United Nations in Geneva before returning to Delhi. There, he had been practicing at the Supreme Court and the Delhi High Court and has been designated as a senior advocate by a unanimous court. He has appeared in a range of matters covering a diverse range of subjects from commercial to constitutional law. He was the counsel for Navtej Johar, Keshav Suri, and others in the case that led to the reading down of Section 377 of the Indian Penal Code. He also argued the case seeking recognition of same-sex marriage before the Supreme Court. A self-described accidental activist, he also is the managing trustee of the Nas Foundation Trust, the NGO that first fought for decriminalization of homosexuality in India. He has edited Sex and the Supreme Court, an anthology about issues relating to law, gender, and sexuality, and has also authored the books 15 Judgments, Cases That Shaped India's Financial Landscape, and Who is Equal? The Equality Code of the Constitution. On the criminal side, Mr. Kirpal, senior advocate, has made immense contribution by his appearance in matters concerning personal liberty, especially cases involving preventive detention. For instance, in Sanjay Kanubhai Tanti versus Superintendent and others, Mr. Kirpal, appearing for the petitioner, successfully challenged the detention order arising out of Kauf Posa proceedings. The Supreme Court observed that the detenue had been denied an effective opportunity of hearing, as the notice of hearing was served only on the very day of the proceedings, depriving him of any chance to seek assistance. Furthermore, his requests for translated copies of documents were arbitrarily rejected without reasons, and the rejection itself was communicated on the date of the hearing. The court held that these glaring deficiencies reduced the proceedings before the advisory court to a mere formality. Consequently, the detention order was set aside. In Choit Nanikram Harchandani versus State of Maharashtra and others, Mr. Kirpal mounted challenge to the preventive detention order under the Kauf Posa Act on various grounds which found favor with the court. The Supreme Court found that the detenue had been unlawfully denied the right to be represented by legal counsel before the advisory board. While officers of the sponsoring and detaining authorities were permitted to appear and assist the board during the proceedings, the petitioner's request for counsel was summarily rejected. The court held that such denial of equal opportunity constituted a violation of Article 14 and fatally undermined the fairness of the proceedings. Accordingly, the detention order was quashed. In the context of today's discourse, it may be noteworthy to point out that Mr. Saurabh Kirpal also appeared in Nikesh Tarachand Shah versus Union of India and another for the accused, wherein the vires of the twin conditions contained in Section 45 of the Prevention of Money Laundering Act 2002 were tested. Mr. Kirpal has been appointed amicus by various courts in cases involving diverse, abstruse, and sensitive legal issues. With his able assistance, the Delhi High Court laid down guidelines for the swift removal of objectionable content online by intermediaries in order to minimize the trauma of a victim. We will now begin by requesting Justice Muralidhar to speak on the topic, The Legal Services Project, Has It Worked?
Good evening, everyone. Justice Dayal, Saurabh, and all the distinguished members of the audience. Can't help beginning with a kind of a joke. So there was this program in the India International Center many years ago. Lord Gough had come, and he was to give the address to the entire audience. And there was a very distinguished senior advocate to introduce Lord Gough. So those days in IIC, at 8 o'clock, if you don't finish, they'll start switching off the lights. So you have to finish. So the program began at 6:30. Today we're beginning at 7. And Lord Gough was being introduced till about 7:30. So when Lord Gough came to the rostrum like this, he said, "I'm happy to see a printed text of my speech in all your hands, and I will take it as read." So that senior advocate was himself giving a lecture some months later, and he was being introduced, and they said, Mr. So-and-so needs no introduction, he only needs a conclusion. There's another part to it. So the next time, word got to the senior advocate. So the next time somebody went to invite him, he was very cautious. He said, how long do I have to speak? They said, sir, for a person of your eminence, no time limit, but the audience will listen to you for about 20 minutes. So this is what we told ourselves now on the dais, that all of you listen to us for about 20 minutes each. This is a topic very close to my heart. So when they asked me what would I like to talk about, I said this, the legal services project. As was told to all of you by Shreya, this is a work of my PhD, and there's a book on that, but much has changed. That book came out in 2004, my PhD was 2002, so we're talking of more than 2.5 decades. And some of the basic problems with our legal services project remains, and that I'm going to speak about. But there are many positive things too. And first and foremost, I must say, having traveled to various high courts, that the legal services that Delhi lawyers provide is among the best in the country, undoubtedly. And they work with a lot of passion, commitment, and when you hold up a kind of example for others to follow, I invariably talk about the Delhi lawyers, many of whom have done remarkable work in the courts, either appearing pro bono or amicus curiae or as legal services panel lawyers. But today we're going to talk of the broader aspects of legal services. An ideal legal services model should have 3 elements. One is the preventive element, which will include providing counseling, advice, pre-litigative resolution mechanisms, and at the nearest point in time and within easy reach. So one of the earliest examples was victims of domestic violence or working women facing sexual harassment. So you have a judgment way back in 1996 of the Supreme Court of India, Delhi Domestic Working Women's Forum, which talks of a scheme for legal aid. And many, many years later, I remember Aparna Bhatt, appearing for the Delhi State Commission for Women, helping the Delhi High Court formulate a scheme. But at the earliest point in time, before litigation starts, the counseling and advice that victims need, even others who are picked up as suspects need, is immense. And that is an element of legal aid which we have to bear in mind when we frame a legal services model. Second, of course, is the remedial aspect, which we are all engaged in. We ensure that nobody goes underrepresented in the court, and you get competent legal assistance. And the third aspect is the rehabilitative aspect, where it expands the notion of legal services. Much after the so-called litigation is over, there are many a litigant needing help to navigate, the system. For instance, bonded labor, child labor, who are rescued in raids, and I'm sure Anish and other judges of the Delhi High Court will encounter this if they've not already done that. This is the biggest challenge before the judiciary. We can pass orders for preventing the employment of children in labor, but what do we do after we rescue them? This is the biggest question before us as courts, as judges, and it is another instance of incompleteness of the efforts that we make. So these 3 broad elements in any legal services model should help us test how effective our legal services model is. The legal services history has gone through several phases. In the first phase, we talked about it in a very narrow perspective, which is providing every person in need of defense or in need of pursuing a litigation a competent lawyer in the court. This is among the earliest forms of legal aid, which predates our independence. And it has still remained a major need in our court. And it's not possible for us to say, even in 2025, that at every level of the judiciary, and when I mean every level, we start at start at the level of the magistrates court or the municip's court, whether at that level of the court are we able to provide competent legal representation. And we shouldn't have only Delhi in mind when we talk about this, or the Delhi High Court or the Supreme Court, because these are not the exemplars. The regular court, I'm talking of a court in Baleshwar in Orissa, for instance, or a court in Begusarai, or a court in Silchar in Assam. So you have to look at all those situations and ask yourself, is our legal services model designed to ensure that every litigant entering the court system who's unable to afford a lawyer can get competent legal assistance? Then we have the expanded notion of locus standi, typically like Hussain Ara Khatun, the whole PIL movement. Many people couldn't reach the court, under trials languishing in jails, not being produced before the courts, having served more than half their sentence, sometimes the entire sentence, and still trial not happening. So that was the second phase where the court reached out to the people. In fact, if one reads the early reports, whether it's the 1971 report of the Gujarat Legal Aid Committee, which was then chaired by Justice P.N. Bhagwati, or the 1973 report authored by Justice Krishna Iyer, or the 1977 report co-authored by both Justice Bhagwati and Justice Krishna Iyer, you will find an important component of that report talks about public interest litigation as a form of legal services delivery. So PIL was seen as an important tool in the whole legal aid movement, where causes of several people in need of legal services could be taken up before the courts in a representative capacity, in a public representative capacity. Then, of course, you have the third phase, ADR, mediation, arbitration, conciliation, lok adalats, and that's very much amongst all of us, and we keep talking about it day in and day out. And the fourth, I would add to all of this, the fourth phase is the global services, legal services movement, the provision of dispute resolution mechanisms on the internet. So this is the fourth dimension of legal services delivery. So in our own country, when anyone wants to start studying about what legal services is all about, you start with the criminal justice system because the Constitution provides for it. There is one provision in the Constitution, which is Article 22, which talks of the three rights that any person who's arrested has. One is to be informed of the grounds of arrest. That's written into Article 22(1). Second, to be defended by and to be able to consult a lawyer of one's choice. This is the second right. And the third is to be produced before a magistrate within 24 hours of the arrest. So all these things which came from the 1898 CRPC were straightaway written into the Constitution. That's because we removed the due process element in Article 21. If you read books by Rohan Alva and other scholars in the recent past, you will know why these provisions were written into Article 22 of the Constitution. But 22 also has a disappointing provision. It says these rights that a person under arrest has will not be available to a person who's under preventive detention. So imagine Constitution denying this right to be informed of grounds of arrest to a person in preventive detention. So I would say it is an aberration in the Constitution. Second is if a person is an enemy alien. Fortunately for us, after Article 39 capital A was introduced by the infamous 42nd Amendment, which brought into the Constitution several other provisions which were later either struck down or taken away with the 44th Amendment, this provision, Article 39A, has stood the test of time and has led to enactment of the Legal Services Authorities Act 1987. And for those who may not be aware, it took another 8 years for this act to actually get notified. Although it was made in 1987, it required another public interest litigation filed by the Supreme Court Legal Services Committee to force the central government to notify the Legal Services Authorities Act. It went through several amendments between 1987 and 1995, even before it became operationalized. Now you have an institutional model of legal services delivery. You have the National Legal Services Authority at the top, the State Legal Services Authorities, the High Court Legal Services Committees, then you have the State Legal Services Authorities, then you have the District and Taluk level Legal Services Committees. So there's a whole hierarchy of legal services committees. And the basic model is for this to be annexed to the formal court system itself. So typically all these legal services authorities will have their offices within the court buildings. And this is, I would consider, not a very positive feature, because persons coming to seek legal services view this as part of the formal legal system and think that it is also going to be bogged down by the same problems of the formal legal system. Of course, there is a conscious effort made by some of the legal services authorities to project a very positive image of what that authority can do. And there are, of course, good practices and not so good practices. And that is for a longer lecture of analysis of what the legal services authorities are all about. But the point is this: it is entirely dependent on the initiative of judges. And you know, within our system, judges are overworked. The same judge who has to supervise the entire district is also chairing the district legal services authority. And he has to make sure that those programs are carried out, right panel lawyers are chosen, and outreach programs are conducted regularly, awareness programs are conducted regularly. So a lot of burden is placed on the chairperson and secretary of a legal services authority. And this forces them to go out into the public and interact with a wide range of actors. So one of the questions we were asked in a presentation made in the National Judicial Academy is, how far is it correct for a judge who's conducting proceedings, judicial proceedings in court, to actually step out of the court and start interacting with, let's say, the merchants association of that area, or other groups who may be in need of all kinds of and whose help may be needed in organizing, for instance, a Lok Adalat. When they organize these Lok Adalats, mega Lok Adalats, they need the cooperation of the local administration, but even the local population. So this is a valid question that is being posed, because we've placed the responsibility for delivering all the promises made in the Legal Services Authorities Act on judges, on sitting judges themselves. So this is a question that definitely arises in this kind of a model of legal services delivery. I'll then cut through a lot of other things. What I find as a positive aspect is there is a constant attempt at the level of the national legal services authorities to bring in newer schemes that seek to expand the range of legal services. For instance, you have regulations talking of duty solicitors in magistrates' court. How well that works is, of course, another issue altogether. I find now, in the recent past, they have a retainer system. They have a legal aid defense counsel who's like a retainer and given a monthly honorarium of 40,000, 30,000, 20,000. And they also have a mentoring committee, which I find very interesting. A monitoring mentoring committee. I found it in the regulations issued by NALSA. I don't know how many of you are aware of all of these things. So the attempt is to increase the quality, because one feedback that all of us have got as judges who've been part of all these legal services authorities is that the quality of lawyers who are appearing in these matters, whether it's in civil courts or criminal courts, is not as good as it should be. And there are a variety of reasons for it. One common reason you will find given out is that we don't pay the legal services lawyers as well as the market pays a regular lawyer. One way of solving this issue is to pay the legal services lawyer the same fee in a criminal case, for instance, as the prosecutor would get paid. That's one way of looking at it, so there is an equality of arms. The other is to depend on the good-heartedness of the lawyers. But that's where there's a big failing in our entire system. India is perhaps the only country where litigants pay for the welfare of lawyers. There is an Advocates Welfare Act and there's an Advocate Welfare Stamp. Orissa, of course, is taken to a different level. Even the senior lawyers have a welfare stamp. So the litigant ends up paying a lot of these additional fees. So on a wakalatnama, you will have stamps worth almost 50, 60 rupees. Much of it going to welfare of this lawyer's group, or that senior lawyer's group, or even the law clerk's group. So litigant actually pays for the welfare of the lawyers. And I've in fact addressed meetings of lawyers where young lawyers ask me, okay, you talk of legal aid to the litigants, what about legal aid to the lawyers? That also shows us there's a huge divide. The truth is that 80% of the work, even at the smallest courts, will be controlled by 20% of the lawyers. And it's seen as a market for services. So, you had a wonderful organization here in Delhi called Ashray Adhikar Abhiyan. I don't know how many of you have heard it, about this organization. And they work among the homeless in Delhi. People who sleep on the pavements, street children. They work on those, amongst those people. They set up, when the Prevention of Begging Act was still prevalent, it was struck down later by Justice Geeta Mittal's bench, you would have cases regularly come up in the beggars' courts in Kingsway camp. So this Ashray Adhikar Abhiyan had a panel of 3 or 4 lawyers, completely dedicated, and they set up a desk in that Kingsway camp court. The next thing you know is the local bar association smashed that desk to pieces. The local bar saw it as a threat to their profession, their opportunities. So this tension that works out at the lowest level, at the level of the magistrates court and the district courts in general, is even today very much prevalent. So legal aid lawyers do not have an easy time when they have to stand on par with lawyers in that field or in that bar. Because legal services, unlike in the US and UK, is not an initiative that has come from the bar in this country. It has always come from the state or from the courts. Even today, it is a formal model of legal aid, which is an institutional model which is financed largely by the state, not so much through donations and other private initiatives. This explains why the bar is not fully invested yet in legal services. Of course, we try and incentivize, we try and say that you will be given special recognition for doing legal services, but I don't think we are doing enough. So one suggestion I would have is to call out lawyers who are doing remarkable legal services and honor them publicly. And that could be an incentive for even the younger lot to come forward to deliver legal services. What happens in the metropolis is also this, and I must mention this is a cause for worry. Some young lawyers who are looking for work think that the best way to start getting work is to get empaneled on the Legal Services Committee panel. So that is a problem, because we really need, for cases involving serious long sentences like 7 years and above, we need lawyers of experience to be able to even conduct a cross-examination, to analyze forensic evidence, to know how to what strategy to adopt. And you can't give it to lawyers with no experience. And that again it becomes counterproductive, because the kind of legal assistance that the court is looking for, the court is unable to get from lawyers of very little experience. So some years ago, when I was part of the Supreme Court Legal Services Committee, we decided for appeals involving offenses of 302 or 376, or where death penalty is been awarded, that there must be a combination of a senior lawyer and a lawyer of between 10 and 20 years of experience. And that would give some degree of assurance to the court that it will get quality legal assistance. Very often when we read the trial court records, you find that the cross-examination has been perfunctory or not at all, and there is actually a failure of the legal services lawyer to put up a proper defense. Which is why I'm saying we should not compare what happens in the High Court in Delhi to what happens in the trial courts, and generally trial courts across the country. So while we might get good lawyers at the level of the High Court, where we need the most is the level of the magistrates and district courts, the sessions courts. And there we're not finding that quality of legal services. I'll generally reflect on what I think are the large barriers that we have to deal with. One is there is a reluctance on the part of people generally to engage with the formal legal system. They have a negative view of the legal system, and that is perfectly understandable. If you have to go to a police station, if you have to go to a lawyer, if you have to go into a court, for many a lay person, this is a very negative outcome, and there's something to be avoided. Let's do anything to avoid going to a lawyer or going to a court. So now to project to people who have a general distrust of the legal system that here is a legal services model that can actually deliver, hold your hand, help you navigate the system, we have to work extra. When I was a legal aid lawyer myself, I have had many a legal services client come to me with money to say, we were told that unless we pay you extra, you're not going to deliver. I'm sure many a lawyer here has encountered the same experience. They don't trust. It's like the ration shop syndrome, right? you don't get the best quality of food grains in the ration shop. So that we have to work at improving the image generally of our legal services institutions. Second is, there is in place in this country for years on end, I'm talking of maybe thousands of years, a non-formal system. That non-formal system is robust, and that is a system that people readily engage with. And it speaks a language which they readily understand. It metes out punishments which they readily recognize. These may not be the kind of verdicts that we'll accept as people who believe in constitutional values and constitutional principles. I'm talking of, let's say, the Katta Panchayats in the south, or the Khap Panchayats just 40 kilometers away from Delhi. The verdicts that those so-called adjudicatory bodies mete out is completely unacceptable to many of us. But again, then we have to engage with those systems. We can't be in silos, right? Because people are caught in those systems as well. An interfaith couple which is running for safety is actually running away from that so-called non-formal system and is seeking help in the formal legal system to tell us, to ask us, will the Constitution work for us? So this is another challenge before all of us who are in the system, to be conscious and aware that in India, at all points in time, we have to contend with what we call as the non-formal system, which is equally robust and equally effective from a certain point of view. And they mete out punishments like ostracization. You can't enter this village. You can't be part of this community. That is so severe a punishment that people think twice, thrice before seeking to assert their rights in that kind of an environment. This is something that we must be aware of. Third, the agenda of our Legal Services Committee is a kind of a bit skewed. We come into great enthusiasm for Lok Adalats, mega Lok Adalats, mass Lok Adalats, which should not happen. I'm not for a minute saying it should not happen, but it can't be the only program that we are visibly doing. There has to be a range of other things that we do. And we shouldn't get carried away that we've settled 80,000 cases in a day, 2 lakhs cases in a day. National Lok Adalat, we settle, let's say 10 lakh cases also a day. And we collect fines, traffic fines to 40 crores, 50 crores. It's all at one level. Yes, some cases are getting closed, but there are a large number of other cases which routinely appear in courts and are getting adjourned without any, conclusion. So we need a proper audit, and we need a people's audit of the legal services system. It can't be just an institutional audit, because we will immediately be able to explain, listen, given the limited resources and given the constraint on personnel and how judges have to do everything themselves, this is all that we can be expected to do. It doesn't answer the litigants' need for quality justice and quality services in courts. So this internal audit is not enough. We need an audit by users of the system who will tell us what they find difficult in navigating our courts and our systems. So the second thing which I want legal services authorities to take up on a very serious note is simplifying the language of the law. We don't have ready reckoner kind of things which people can easily use. I'm sure Anish and Najmi is here. Very often, Anup, you've seen the last rows in our court, right, where the litigants sit. And you can, Mukta has also noticed this bewildered look. The lawyer has told you something, you've told something to the lawyer, and the litigant has no clue what's happened. So, and you can find them going a bit dazed. क्या हुआ था court में? Judge ने क्या कहा? आपने क्या कहा? So now, because of some of the live streaming, they're able to kind of catch. But some judges are getting very clever. They switch over the mics when they dictate the order. So we have to work at simplifying the language of the law and also demystifying the whole process in the court. So that is something that we need to work on. And we can use the services of young lawyers. I've often suggested this, that the frequently asked questions in every branch of the law. If it's a check bouncing case, I know for a fact, and we tell it as a joke, the man goes to the person who's received the notice under Negotiable Instruments Act, goes to the lawyer and he says, check ka amount kya tha? and he says 5 lakh, he says 10% court fee lagega isme. Not knowing that for a criminal matter you don't have court fees. So, even basic things litigants are unaware of, and they get exploited. So as legal services authorities, I think we need to do this, put it out there in the public domain. How do you negotiate through the court system for different kinds of cases? And what should you expect? Using technology, you see, we should be able to open up as a 24/7 service in legal services authorities. And I'm not talking just of Delhi or the major metropolises, but throughout the country. And what is the response time we have to a complaint that's sent to us on the internet? And we need the cooperation of the bar. Without the bar, we just can't progress. We should incentivize the bar to come forward to lend that helping hand at all levels of the court. Again, I insist on this, that we shouldn't talk only of the Supreme Court and the High Court. Most importantly, we should talk of the trial courts, which is where they're in competition with the legal services lawyer, and we'll have to see how that is tackled. And it increases. We should see the legal services authorities as increasing the faith of the common person in the court system. And if we work towards that, I think there's a better future for all of us. Thank you.
We are grateful to His Lordship for gracing us with his wisdom. We will now have Justice Dayal speaking on the topic, Adolescence and the Law, Safeguarding Rights, Ensuring Justice.
Justice Muralidhar's erudition and experience was a very hard act to follow. So I'll start with that disclaimer. But thank you so much to the organizers, in particular Harsh and Akshay, who had a tough time persuading me to accept. But Justice Bambani, who's mentored this whole project, also had to nudge me into accepting this. Partly because having Justice Muridhar, Saurabh, who's a brilliant scholar, and senior judges, including my mentor, who taught me all of criminal law that I know, so I can blame it all on her, Justice Mukta Gupta. I'm having a bit of an imposter syndrome. Having not dealt with these issues as a commercial practitioner when I was a lawyer. So let me sort of demystify as to why I chose this subject. Adolescence is a stage we've all gone through. But since memory is kind, we remember the good parts, and we don't remember the struggles that we went through as adolescents. But now, I'm a parent of an adolescent child. So I am an observer, I'm a participant, I'm a peacemaker, I'm a conflict manager, and therefore I'm legitimately a stakeholder in adolescence. So that's the first reason. The second is the Netflix series Adolescence of the same name. I don't know how many of you have seen it. Can we get a general set of hands? Okay. Okay. But you must see it. And a lot of my address today is it's underpinned on that, but let me go through it. It is 4 gritty episodes set in the north of England, centered around a 13-year-old boy from a regular middle-class family with a mother, father, and a sister, arrested for murder of a girl in the school. For those who are not familiar, the character is Jamie Miller, played beautifully by Owen Cooper, who, if you've read the news, has recently got an Emmy as one of the youngest actors, just about a few days back. The episodes move from the incident, the 4 episodes. So they move from the incident to the police arrest and the investigation. It's heart-wrenching, believe me, when you see it. Followed by the family's struggle with guilt and denial, reactions from the school, the community, and the peers, and then to an intense 3rd episode, which is my personal favorite, on the interaction between Jamie and the counselor, Bryony. And finally, to a denouement of Jamie admitting to the murder. The series is tightly wound innovatively filmed because it doesn't have edits. The camera keeps moving, and caught the attention of the world, since it brought to the fore the complexities of an adolescent mind, its vulnerabilities, the role of digital media, peer pressure, cyberbullying, toxic subculture, misogyny, radicalization, helplessness of the family, process of interrogation and investigation. The reason I'm pointed this out, for those who haven't seen it, will probably prompt you to see it, because in those 4 episodes, the subtext is so strong. So Adolescence did not only sketch out Jamie's story, but brought center stage the issues around youth offenders, the societal factors and their motivations. The third reason that this topic was chosen, that I currently, as was mentioned, I happen to be part of the Juvenile Justice Committee of the High Court. And these themes and issues which rotate in my mind, and when you see this series or when you read something, propel me to think as to how we ourselves deal with adolescence issues within the criminal justice system. After all, as part of the committee, we are responsible for certain decision making. So I've chosen this broad structure as an underpinning for a larger discussion. There are various strains, threads, and subtexts, as I said, which will be impossible to explore. But 3 stand out in my mind, which will be useful for our discourse today. So I'll ask these 3 questions to myself, and we must ask them to ourselves. First, do we really understand the adolescent mind? And I'll address a bit on that. The second, what is our responsibility as parents, peers, educators, and justice system? And 3, are we dealing with the gaps, or are we in self-denial? Interestingly, Jamie's father, Eddie, in the series, doesn't know what happened. He says, my child was a normal child. And he keeps on asking in the parental interaction that he and his wife has, we have done nothing wrong, have we? This could be any family. And it sort of crystallizes in this very sordid way that how close a youth offender can be to you. So what are we assessing effectively? What makes the child an offender? How sensitive is the investigation and punishment process? And third, how effective are the steps for rehabilitation? And that's really my address. A stark theme which was evident in the series, and note this, was the perception that children who come from dysfunctional backgrounds are headed towards path of criminality. Jamie was from an ordinary family, referred to as bright and smart, and therefore did not fit this narrative. Suggestions were made that he was abused at home, but that was not so. This triggers us to consider the assumptions that we make, that the factors which contribute to making a child an offender. So the first issue I'd like to address is on the issue of appropriate terminology. In the discourse, I've chosen to use the term youth justice system and adolescents instead of juvenile. While our primary legislation is titled Juvenile Justice Act, on the other hand, there's no statutory definition of adolescence. The WHO, our research says that the WHO defines adolescence as a phase of life between childhood and adulthood, from ages 10 to 19. The Juvenile Act defines child in section 2(12), and then bifurcates it into 2 categories, child in conflict with law and child in danger for care and protection. POCSO also defines child as anybody below 18 years. So that's how the stage is set. Point to mull over is whether this broad definition, expansive, to assess all children, irrespective of age, is correct or not. So therefore, a 7-year-old and a 17-year-old will be assessed by the same set of procedures. It's a thought. Interestingly, the Act only uses the word juvenile on the title. but not the text. Comprehensive analysis of the Act has been done by Dr. Ved Kumari. Justice Muralidhar introduced me to her scholarly work, Professor, Faculty of Law, who posits that the term juvenile is linked to delinquency, and that's the justification, and presumes guilt even before adjudication. So commentators have decided, or some commentators use the word youth system, youth justice system. In fact, this is embedded in the UK legislation. The UK legislation uses a youth justice board. So maybe we can quibble about phraseology, but why maybe not think of evolution from 2025 onwards and use phrases which don't stigmatize. So that's the first thought I'd like to put forward. We have used politically correct terms for other situations. We don't use handicapped, we use specially abled. And I was trying to find research that how has it helped the degree of sensitivity when we choose a much more nuanced and sensitive phrase. The second issue in my mind is of cyberbullying, which Jamie goes through. Let me put some data at you. In a paper published in 2024 called Silent Screams on cyberbullying amongst Indian adolescents, it was stated that India reportedly has the highest incident of internet harassment. So all of us are responsible. It's not happening somewhere out there, it's happening within us. In the year 2020, a total of 50,000 cases were reported of cybercrime. NCRB records show that from 2022, there's an increase of 24%. The Child Internet Safety Report of 2023 says that children owning smartphones between 6 and 10 years is 60%, 11 to 15 years 85%, and 16 to 18 years is 95%. And the average time spent is 2.5 hours to 6 hours a day. So what is cyberbullying? Cyberbullying takes many forms. You'll be surprised at how many issues arise. I'm sure that you're all practitioners and you would have come. So it's shaming, embarrassing, degrading, humiliating, impersonating, threatening, obscenity, and stalking. Some scholars prefer to use cyber aggression than cyberbullying so that it doesn't sort of conflate with the traditional form of bullying because it's gone much further. In the US, as far back as 2006, there was a case of Megan Taylor Maya. She was a 13-year-old girl from Missouri, died by suicide less than 3 weeks before her 14th birthday. She was communicating on then what was popular as MySpace with someone whom she believed to be a 16-year-old boy called Josh Evans, which in reality was a hoax created by a neighbor, Lori Drew. The messages from Josh turned progressively cruel, and the last message was, the world would be a better place without you. Megan locked herself in a closet and died. Lori was convicted under the Computer Fraud and Abuse Act of USA, but due to lack of proper legislation, more serious charges were dropped. There is no single specific federal law in the US, nor in the UK, on cyberbullying. And what do we have here? In India, there's also no specific provision, except you invoke certain provisions under the Information Technology Act, which relate to identity theft, cheating, violation of privacy, publishing sexually explicit material, etc., and possibly IPC and BNS, or stalking and criminal intimidation. So we need to evaluate this. That's the second thought. The third concern is what is so different and special about the adolescent mind, which I spoke about. And here I like to present some scientific research for which I'm quite, I must attribute it to Medha Pushkarna, who's possibly present in the audience today, whose dissertation, recently concluded dissertation in an MPhil from Cambridge University, I have copiously borrowed. So I must thank her. It's a brilliant dissertation. But the Nirbhaya case in 2012 sparked huge criticism, since one of the accused was 17 years old, legally a child, amenable to a lighter sentence. But after a public outcry, as we all know, the new bill passed muster, and 16 to 18-year-old accused of heinous crimes had to go through preliminary assessment. This was criticized. Now, that is not what we are planning to discuss, because that's a separate thing. But what does adolescence involve? So the UN Convention on the Rights of the Child in Article 5, and I'm making this sort of thesis out, uses the word evolving capacity. So just let that stay with you. And what does it point to? It points to underdeveloped socio-emotional system, making susceptible to impulsive behavior. As per neuroscientific research, during adolescence, brain regions responsible for impulse control and behavioral regulation are still maturing. On top of that, you add the digital environment, including internet, social media, video games, which impact the cognitive development and emotional regulation. Research shows that adolescents engage in risky behavior despite understanding potential consequences, since parts of the brain are yet to mature. So we are dealing with that cohort, because that's the subject of our discussion today. So what happens? A disconnect happens between knowledge and action. While an adolescent with a high cognitive development, that's what happens when you suddenly start growing up, will grasp the risk of behavior, but it will be unable to apply this understanding in an emotionally stressed situation. And the result? An adolescent's action may not stem from the ignorance of right or wrong, but from neurobiological immaturity. Therefore, how do we evaluate culpability and intent in the youth justice system? Do we factor in youth immaturity, which prioritizes immediate gratification and unable to assess long-term consequences? And also the big factor, peer pressure, which interestingly in Jamie's case was heightened by the fear of social exclusion, leading to rejection, because he had this, just to the story, he reacts to, and he gets into a cult of misogyny, because he's been told that he likes a girl, and the girl tells him that you are so ugly, I'll never be attentive to you. And this is happening, and it leads to murder. So we can't ignore it. So vast amount of scientific research should propel youth justice systems, and this is my proposal, to evolve a nuanced assessment of capability, considering that autonomous decision making is heavily influenced by emotional, social, and neurobiological immunity. Now, in the preliminary assessment under the JJ Act, as we understand, the JJBs conduct traditional IQ tests, because that preliminary assessment ultimately ends up in the child being sent to the children's court to be tried as an adult. It was mentioned in the introduction about my judgment in CCL, which revolved around a joint trial. And don't need to repeat it, but the issue was, what's the difference between being tried as an adult and being tried with an adult? If you focus on it carefully and mull over it, it's a stark difference in approach. So even after a reference to the children's court, the offender does not become an adult, but has to be only tried with an adult and not as an adult. So it was a beautiful nuance which sort of cropped up in the contentions which were raised before me, and it was informative and educated to actually go through that research. The Supreme Court in Barun Chandra Thakur dealt with the case of a CCL accused of killing a class 11 student in the toilet of his school, 16 and a half years old at the time of the crime. The Supreme Court variously held that the JJ Act and the model rules do not lay down any guidelines or framework to facilitate JJBs in making a proper preliminary assessment. In that case, only a mental IQ test of the child was done, and no report was called by the JJB. The board only provided 30 minutes time to the child, his lawyer, and his father to peruse the 35 pages of the report, which was too little for them to cobble together evidence and rebuttal. And I'm quoting I'm mentioning the apex court, because the apex court in this context this very context of an adolescent mind and capacity, in Barun Chand Thakur said, evaluation of mental capacity and ability to understand consequences cannot be relegated to a status of a perfunctory and routine task. And a meticulous psychological evaluation must be done. So therefore, the next thought is, what is required is a justice system which is anchored in contemporary science and is open to evolution based on practice. On the next thought, so what are our duties? We understand all this, and what are our duties? In Sampurn Behora, Supreme Court starts with a question. What can a citizen do if the state pays no attention to his or her fundamental or human or statutory right? And what if that citizen is a voiceless child or someone whose voice cannot be heard over the din of governance? This was in the context of virtual non-implementation of the tardy implementation of the juvenile system. I have experienced in our JJCs, there are a plethora of organizations. It's sometimes so difficult to understand, just as Muridhar talked about the legal services, but it's amplified in the juvenile systems, and our senior judges are here and they've all experienced it. And sometimes you're wondering as to who's actually doing the job. Who's doing the job? How much of the job are they doing? What is the overlap? Who's the decision maker? What is the control system? Plethora of organizations. And it's sad, actually, that despite all this, the childcare institutions in the country are not short of a nightmare. There's a report by Justice Chandru, former judge of the Madras High Court, regarding state-run home in Tamil Nadu for CCLs. According to his report, he visited 13 homes in 10 districts. Children were subjected to violence, bad sanitary conditions, locked indoors, barely get sufficient food, do not have access to counselors. One of the homes in Coimbatore he termed as a house of horror. I'm sorry, the context of our discussion will not generate any humor, but that's what we are discussing. So therefore, what is required, which is also provided in the JJ Act, is inspections, audits. And this is in a different context of what Justice Muridhar just said. But the inspections have to be carried out in earnest. Now look at the example when Tata Institute of Social Services went on a social audit in Bihar and ended up actually figuring out there was a sordid tale in Muzaffarpur of sexual abuse. We all know that case. I'm sure it's crossed us, but the details of this case are sordid. Whoever, as a practitioner and as judges, we have gone through it. So that is one part, the darker part, which we need to address very seriously, very seriously. But on the other hand, what gives us positive, there are some examples which give us positive light. For example, I was reading about this home in Bangalore. As part of rehabilitation, they organize yoga, meditation, art therapy, and they have clean and hygienic conditions, including, importantly, clean linen. So the founder of the non-profit organization that manages the home stated that those who left after completion of their terms did not come back. They had no cases of recidivism. Now, what is important is our constitutional duties and JJ Act duties. But what is important is that, and I'm emphasizing this, that a child has to be placed at the center of the policy and decision making and for designing the programs. One of the principles in the JJ Act, in Section 3, is the principle of participation. I was very glad it is there because it says every child shall have a right to be heard and to participate in all processes and decisions affecting their interest. The Act provides it. But even I, when sort of went through the Act in more detail, thought it is exemplary that it is there. So we come to retributory justice, to rehabilitative justice, which is one of my favorite. I hold that very close. this, the retributive model and the rehabilitative model. So in the youth justice context, what is more amenable is they are more amenable to reform, guidance, and support. So therefore, the over-institutionalization has been largely criticized. Recently, I had the occasion to also monitor the aftercare guidelines, which we drafted as part of the JJC. And we introduced what is called the individual aftercare plan. It's to take care of children who after 18. So how are you holding their hands after 18? And how are you preparing them? So we prepared this in 5 phases, that the aftercare starts at 15, so that slowly you monitor them and move to them. And even as per the other principle in the JJ Act, which is the principle of a fresh start, whether you are anonymizing their, Justice Bambani would know this, we are working at so many petitions of anonymizing, because otherwise they'll always be there with the stigma. The Supreme Court in Ramesh Bishnoi also notes this. Somebody was not getting a job because there was some frivolous case against the person for holding a girl's hand at some point of time, and the parents had pardoned him, and he was still not getting a job because he was there. So that is another issue. If I would like to conclude this thought process in one line, I would say that a child in conflict with law and the children in need of care and protection are really just 2 sides of the same coin. And that's something that we need to think about. I'll leave you with a quote. When we were doing our research, I came across from a 17-year-old from Monaco who said, and I quote, "We are not the sources of the problem. We are the resources that are needed to solve them. We are not expenses. We are investments. Call us the future, which we do, but we are also the present." So I leave you with that thought, and thank you so much. Slight
We are thankful to His Lordship for this illuminating lecture. We now request Mr. Kirpal, Senior Advocate, to hold forth on the topic, Twin Conditions Restricting Bail Under Special Statutes, a Judicial Dilemma.
I'm going to take Justice Muralidhar's warning very seriously. The lights are going to go off here at 8 p.m. So I have about 12 minutes. I'll speak very fast so it feels like 3. And the reason lights go off here at 8 p.m. of course is because the bar is open at about 7:30 in the International Center. And anyone who comes regularly to the International Center knows that the main reason to come there is not to hear boring people speak, but to go to the bar instead. So I'll keep this short so you can all have a better Friday night than to hear wise men and one not so wise young man speak. So I'm speaking on a topic which is tough to make exciting, but it is certainly something which is extremely important. It's important not only in the nuance of what twin conditions mean, when do we get it right, when do we get it wrong. I think it reflects a fundamental issue of what criminal law is and what is the relationship between the citizen and the state. We live in a country that is becoming increasingly more carceral. Everything is becoming a crime. Even speaking out now, your thoughts seems to result in FIRs against you. This idea, therefore, of a carceral state where every citizen is seen as a potential suspect is reinforced by this twin condition system where the process is the punishment. And this is something I will develop on a bit as I go on. But I'll just leave you with one preliminary thought about this idea of the citizen and the state. And that, I suppose, would be when I'll give you one example of an American judge who was dealing with matters relating to compulsory service in the army. And that was struck down by the Supreme Court. But then the judge says that yes, our constitution is a kind of a fine balance. It's meant to give rights to individuals, but it's not some kind of a suicide pact that at the end of no matter what rights you get, if everyone's dying and collective suicide is happening, we will permit that to happen. So that is the kind of feeling that I think judges have in their mind. I mean, there are many illustrious judges here, is that we're always doing the balance between individual rights, which are nosy little things that come in the way of the larger rights of the public. This balancing exercise of freedom on the one hand and the need for national security on the other. And that's found in these twin conditions. This constant tension as to should we give bail or should we hold these people back and secure our glorious republic. So this balancing act is really what causes this mindset of the twin conditions. But in all of this, we forget that the job of criminal law is delivered only when the final verdict comes. In India, unfortunately, the process has become the punishment. Because we find it impossible to convict people, because our investigation is not thorough, or maybe because we simply catch people who are poor, or there's actual malafidis in our prosecution, so that we go after our political opponents. And this is something which is cutting across party political lines, something I will address later. All states want to go after the people who they see as problematic. So if this is the case, then the process is the punishment. Because we can't convict, we have abysmally low rates. Some judge may think that, well, why should I blame judges? Parliament thinks that because it is impossible for us to convict, we will ensure that bail becomes so difficult that the person may not get convicted, but at least he'll get a dose. He'll go and he'll have a little bit. And then that will teach him a lesson not to do this again. And the public is satisfied because rather than nuance and understanding and conviction about rights and liberties of other people, we seem to be baying for blood all the time. I mean, we've become that kind of a country that we want justice, and that justice has to be instantaneous. We obviously can't wait for final conviction because it'll never happen. So let's instead go for carcerality through the process of denying bail. So what is this twin condition? I mean, we say it so often, and you all know it, but for those who are brave enough to come to this lecture without knowing it, let me tell you that there are two real conditions. One is the fact that bail will not be granted till the public prosecutor is given due notice. Now, this is purely procedural. I've never seen bails being granted without public prosecutors being given notice in any case. So this is a procedural formality which inevitably happens in any case. The real sting comes in the second condition, which is really two conditions in practice, and both of them have an implication of what it means for criminal law. So the first subcondition is the fact that you must establish that there are reasonable grounds to believe that you did not commit the crime. And the second is that if the court must feel that if you're released out in the public, that you are not likely to commit the crime again. Now, there are multiple variations in different statutes, but this is the real sum and substance of these two conditions. And if we analyze these, the first condition really flips the concept of presumption of innocence on its head. So rather than assuming that everyone is innocent until proven guilty, you now have this very high threshold of having to establish that I did not do anything, there are reasonable grounds to believe I'm innocent, and therefore give me bail. And here we have to ask, what is the purpose of criminal law? Again, this is what I started with. It's to punish a person for a crime they have done. There are multiple reasons, of course, reformative justice, retributive justice, but this, by and large, in common sense, is what it is. And we also live in a country, and it's not just India, but it is a colonial past which is shown from Magna Carta onwards, that there is a feeling that the police will always overstep and will aim to manufacture evidence, plant people, because their idea is conviction. That's the way state is. That is the nature of power. Inevitably, power leads to abuse of power, which is why we have fundamental rights controlling that. That is why we have presumption of innocence. Because if you do not have that, it will be very easy for the state to just catch everybody, convert this into a carceral state, and that is why we have these fundamental rights guaranteeing that there is this presumption of innocence. But the twin condition flips that, again changing the nature of the dynamic between the citizen and the state. And the second condition, of course, is the fact of are you likely to commit a crime when you are on leave? Now, this is something to me that is far more problematic than the first part. I know when we, as lawyers, argue a bail in a matter of NDPS or UAPA, whatever else, often judgment turns on the former part as to what is a reasonable ground and other reasonable grounds, because the judge seems to feel that I'll give you the bail. But the real problematic part, and that's how a twin condition is abused by governments, is by treating the carcerality, imprisonment, as a form of preventive detention. The idea that you will not do a crime when you are let loose has a corollary that we will keep you in jail because we think you will do something. They're the two sides of the same coin. Now, if we're going to keep you in jail because we think you're going to do something, it shows that it is really an idea of prevention. And by doing this process of having a preventive detention in this manner, you are undoing all the constitutional safeguards that are embedded in the Constitution, like Article 22. Justice Muridhar mentioned Article 22 earlier, and I was slightly scared he'll elaborate on it a bit more eloquently than I can. But Article 22 is one peculiar article which claims to give rights when it actually really takes away rights. When the idea of preventive detention was first being floated in the Constituent Assembly, there was tremendous opposition to it, because a lot of the people who were part of the drafting committee in the Constituent Assembly had themselves suffered under the British Raj and been imprisoned under various regulations. Some of the first the Bengal Prisoners Reform Act of 1818, which had started preventive detention. So we have a long colonial history of preventive detention. And yet, by the time those people who had suffered at the hands of the colonizers came to become in power, that thing that I said that happens when you come to power happened to them as well. They started saying, well, we need to control. India is going through a tough time. The partition is happening. There are communal riots happening. We need control. And so they retained the preventive detention. But even when they retained preventive detention, there were safeguards. You can't have preventive detention for more than 1 year. Within a certain period of time, you have to be taken to an advisory board. That advisory board has to have High Court judges in it. It was sought to be amended. That amendment had never been notified. So there are these protections. So in spite of all these protections, we now have a whole host of criminal laws, NDPS, UAPA, PMLA, most commonly now, where now you arrest people and they can't get bail much beyond the 1 year period. Why bother using coffee posa? Why bother using any other preventive detention? Just arrest people and have twin conditions, which is why we see a kind of a creeping acquisition of the number of statutes that this twin condition is finding its way in. It started off originally in, and I'm grateful to Justice Muralidhar for pointing out that it was in the Defense of India regulation of 70s that this was first, twin condition came. It then came in NDPS. After that, it came in TADA. When it came in TADA, it was challenged, and the Supreme Court upheld it in a case called Kartar Singh. And there also in Kartar Singh, they said that, yes, we are aware that this is a problematic provision, but we are sure it will barely be used. And if it's used very often, then obviously that's an abuse. And that was in the 90s. But the last 20, 30 years, which includes the last 10 years, shows that its abuse is far more rampant than we really should have worried about or thought about. But after, in any case, TADA comes POTA. POTA followed by PMLA. Now that's when I said we're party political. Now remember, POTA is replaced, and after the after the attacks in Bombay, twin conditions are imposed in UAPA by the then government in 2013, which is not the same as the government today. PMLA is introduced by the same government in 2004, which is twin conditions come under a different political regime. So my point is, political regimes will inevitably try to make criminals out of you. So this is not party political. This is just a thing that power does. And after that comes, of course, most recently the PMLA and even things like Companies Act. So under section 212(6) of the Companies Act, you have the twin conditions. Matters that you thought no longer are about national security. Where is the national security in Companies Act? That balancing of public liberty versus public safety. Where is that in PMLA when you have an offense of copyright violation, which also has the same twin condition, etc.? So somewhere along this line, we've moved away from the basic rationale that was offered to us as citizens as some kind of an explanation as to why we have twin conditions. And instead, we've all become criminals, and we can potentially become criminals, and it has also become a mode of social and thought control in people. So that's what the twin conditions do. Now, what's a judicial dilemma? Judges, obviously, by their training, recognize that the police and the state will often attempt to overreach. So they try to control the excess of the state. Now, in the case of these twin conditions, multiple attempts have been made by the judiciary, but much, of course, also depends on who the judges are. So to take the example of PMLA, the twin conditions were originally struck down by a rather liberal bench of Justice Nariman and Justice Kaul on the ground of Article 14 violation, saying that at that point of time, the twin conditions criminalized and were applicable only to those offenses where the scheduled offense was a grave one, but if the scheduled offense was not grave, then the twin conditions didn't apply. Now, this made no sense because the offense under the PMLA is not the scheduled offense, but is the act of money laundering. And if you launder the money, then whether you do it for a minor or a major offense, it doesn't make any difference. And so the court struck it down in Nikesh Tarachand Shah. But the court also said that this is really kind of an abuse. It's arbitrary, manifestly arbitrary. Sadly, this judgment was overruled by a bench of 3 judges in the infamous Vijay Madan Lal Chaudhary case. To me, the peculiar thing about that case is our law is that once a law is struck down, it's gone. It's erased from the statute book, Article 13, it's wiped out. And if the state or the parliament wants to reenact it, it must give a specific provision that here we bring it back, notwithstanding any order passed by any court for the timing or in the past. It's rather like Jesus Christ and raising someone from the dead. So you have to make that effort. And yet, in the amendments to PMLA, that was never done. The underlying basis was undone, which is now the twin conditions apply to every offense under the PMLA, but not, there was no mention that regardless of any judgment. Yet the court at that point of time decided that was enough and proceeded to uphold, or in fact not uphold, rekindle the twin conditions. And a whole host of other things followed in that judgment that shows the mindset of the judges at that point of time who were delivering that judgment. I think that judgment is regressive, it's under review. Hopefully it'll be reviewed at some point. I think it's listed next week. Let's see. On Tuesday. So let's see. I don't know how much hope one has, but we'll see. It's matter sub judice. It's best not to comment. After saying all this, is what I'm saying. Because I do realize I'm on LiveLaw, so you know, we have the utmost respect for the judiciary and yes. And the other way, I think, and I'll try to wrap it up after that because yes, I have 3 more minutes. Yes. The lights are going off, bar shutting. Yes. So the other way they've tried to control the judges and trying to bring some humanity into it is by a principle that your constitutional rights are not erased every time you go into prison. So Article 21, which is, earlier you mentioned Ron Alva's work and the fact that substantive due process was not included in our constitution, yet our judges in Menaka Gandhi and thereafter found that substantive due process is part of Article 21 in some level or the other and read it in. So that glorious article has been used by the judges to say that if you have no reasonable prospect of getting a trial over soon, we can't put you in jail indefinitely, because that amounts to a violation of a constitutional right under Article 21. So no matter what the statute says, a writ court, since it is obliged to protect your constitutional rights, will step in and strike down and release you on bail. Now there also, of course, that is in Najib's case, many cases have been done. There are some Punjab Haryana High Court judges, judgments which came in one of the Delhi cases also. But then we also have other judgments which are more recent from my own High Court in Delhi, where this logic seems to have been forgotten. People have been in jail for 5, 6 years without trial, where charges have not been framed, and yet Article 21 seems to be mysteriously absent from their fundamental rights, from there. But that's another non-LiveLaw discussion. So it really depends. When you have constitutional rights delivered and adjudicated upon by judges, a lot will change on who your judges are. And that's something that citizens should be scared about. I'll just try to close with an anecdote I remember about how Article 21 can be meaningless or can have great meaning. I mean, I remember going to the Rouse Avenue Court and arguing a matter in PMLA and trying to get bail, and I said, my lords will look at Article 21 and there are all the, surely this has been too long, the person's been incarcerated, how can you read this provision this way? And my opposing counsel kind of scoffed and said, what Article 21? All Article 21 has now been incorporated into CRPC. If CRPC does not apply, Article 21 does not apply. You're all laughing, but the judge bought that argument. So, your rights cannot be so tenuous as what the judge had for breakfast or what they think. It needs to be codified, and it needs maybe the Supreme Court finally to step up and reverse some of its judgments, which have been, in the last few years, less protective of liberty and taking the idea of national security as some kind of swaha, which is mentioned every time that a citizen's liberty is threatened, and say that's the answer for everything. Thank you.
We are grateful for Sir's keen observations and inferences. Before we conclude, Mr. Aditya Mukherjee, Advocate, will present a small token of appreciation to Justice Mukta Gupta. And Mr. Vinayak Chittale, Advocate, will present a small token of appreciation to Justice Vaziri. Yes. We also wish to thank Senior Advocate and former Additional Solicitor General of India, Shri Rakesh Kumar Khanna, Mr. N. Hariharan, Senior Advocate and President of the Delhi High Court Bar Association, Mr. Brij Bhushan Gupta, Senior Advocate, Mr. Pramod Kumar Dubey, Senior Advocate, Mr. Sumit Verma, Senior Advocate, Mr. Avi Singh, Senior Advocate, Mr. Ankit Jain, Senior Advocate, Mr. Sanjeev Dubey, Senior Advocate, and Ms. Nandita Rao, Senior Advocate, for gracing this occasion. We thank everyone for taking the time out to be here with us today. I now request all the committee members to come on stage to take a photo with the speakers. Thank you.
side.
We would also request Justice Bhambani to join us. We would also request Justice Bhambani to join us for our photo with the speakers. Yes. And we would also request Justice Mukta Gupta and Justice Waziri to join us for our photo with the speakers. Sir.
Avi.
Thank you for encouraging us like always.
I won't miss this. This is so fabulous. Heavy. This is truly the quality was super. Brilliant speakers.